Welcome to today's EACC webinar, New EU Tech Rules and Transatlantic Business, What Do You Need to Know and How Should You Prepare? Today's program is organized by the European American Chamber of Commerce, Florida, with the support of Greenberg Traurig. My name is Kristina Slezinska, and I'm the Executive Director of the EACC Florida. I'm delighted to welcome you to today's program. Before we start, a few housekeeping issues. This program is being recorded and intended for informational purposes only. The recording will be posted to the EACC YouTube channel and circulated to attendees of this program. Nothing which is said during the program should be construed or taken as legal advice, and any information, questions, discussion should not relate to any client matter or issue that may be considered privileged or confidential. All comments presented by our speakers are their own and do not necessarily represent the views of the EACC or of its members. And if you have any questions for our speakers during the program, please submit them in the Q&A box so that they can be answered during the Q&A section of the program. So if you're watching this today, you're probably aware that we're having a major hurricane making landfall today in the west coast of the Florida Peninsula, with what could be catastrophic floods and destruction. While we here in Miami are relatively spared and able to schedule this webinar with little disruption, I do hope that our member companies in the path of the storm, their staff, and all of my fellow Floridians will be fine. And now, onto the program, and let me introduce our very, very distinguished speakers for the program. Lucinda Creighton, CEO of Vulcan Consulting Ltd, is a barrister, qualified New York attorney, former Irish Minister for European Affairs, and member of the Irish Parliament. Her knowledge of the EU bureaucratic infrastructure and regulatory system is extensive, and as CEO of Vulcan Consulting, she works closely with CEOs and senior management teams to assist them in understanding and navigating the political, policy, and decision-making environment in Europe and Ireland. Today, Lucinda joins us from Dublin. Malcolm Dowden is a partner in Squire Patton Boggs' Global Data Privacy, Cybersecurity, and Digital Assets team. Malcolm has more than 25 years' experience advising UK and international clients on a wide range of technology, data protection, privacy, and electronic communications issues. Malcolm has a particular focus on planning and implementing cross-border data and privacy law compliance strategies. And Malcolm joins us from London. Peter Fatelnik is Minister Counselor for Digital Economy Policy at the delegation of the European Union to the United States. He has been there since 2018, which is when digital economy policy became a top priority in the EU-US relations. Peter is instrumental in defining the US relations in the Trade and Technology Council and is driving the US narrative on European key policies, such as the ones we will be discussing today, or issues related to AI and many others. Peter joins us from Washington, D.C. Alan Sutton is a principal shareholder of Greenberg Traurig and senior chair of the firm's global intellectual property and technology practice. He's an experienced business lawyer with a principal focus on commercial transactions with IP and tech issues and privacy and cybersecurity matters. He has particular experience in internet and electronic commerce issues and has been involved in many of the major policy issues surrounding the commercial development of the internet. Alan is also the president of the EACC Florida, and I'm delighted that he will be our moderator for the day. And now, without further ado, Alan, the floor is yours.
Thank you very much, Christina, and welcome everybody to today's webinar. The internet has transformed the world and ushered in a quantum leap in how people communicate across the globe. It's created a digital market that's has made huge gains by revolutionizing the way people innovate, consume, and access information. But some think that what has emerged is a sort of winner-take-all dynamic where a small group of large companies act as rule makers and gatekeepers. Those who hold this view are concerned that left unchecked, a small group of large private companies runs the risk of suppressing competition and hurting consumers in the long run. They also believe that the current environment is increasingly challenging for smaller businesses trying to create and grow new businesses online. Others have different views. They're concerned that regulators don't understand the internet, while still others are concerned that the new proposed legislation may inhibit core free speech online. And they point to examples of activists, businesses, and everyday people who've been blocked or restricted on various platforms. The European Commission and Parliament are stepping in and are developing new legislation that will allow everyone to keep track of ever-evolving digitizing of services. So what are digital services? Well, digital services refers to any service delivered over the internet that's generally automated and involves minimal human interaction. It refers to things like online shopping, internet banking, social networks, delivery of music and movies, and much more. The digitization of society and the economy has been accelerating now for a couple of decades and creates new opportunities for people all over the world. But many are concerned that it also has created a situation where a few large platforms yield a great deal of power in the online environment. These people argue that large platforms have emerged as effective gatekeepers in a digital market and have digital market power to act as effectively private rulemakers. While at the same time, black markets, hate speech, and harmful content continue to thrive on the internet. They also are concerned that current trends create less choice for consumers and unfair conditions for smaller businesses. Yet others are focused on what they believe to be end users that are exploited by manipulative algorithmic systems used to amplify or spread disinformation. The lawmakers believe they are moving forward to bring more transparency and order to the activities of digital service providers. The proposed Digital Markets Act and Digital Services Act may seem overwhelming and complex, but these acts are not all that difficult to understand. They work together and include a strong call for protecting basic rights in the online environment, calling for transparency, information, obligations, and accountability for digital services providers. These acts also provide oversight at the EU and national levels to promote cooperation between authorities, particularly when addressing cross-border matters. Crucially, the Digital Markets Act strives to ensure that companies of all types behave in a fair manner in cyberspace, and set a set of criteria for designating who would be these so-called gatekeepers, and focuses on stricter obligations on these companies to ensure that smaller businesses that depend on the platforms to offer services will be able to operate in a fair environment. It also aims to increase opportunities for competition with new investors and startups in the technology space while giving consumers a larger number of choices and services and reasonable prices. Today, our panel will explain these new pieces of legislation in the EU, help us understand how they will affect various types of businesses, how these new acts will impact businesses outside the EU. We also will learn when these acts are likely to come into force and address what companies should be thinking about now and in the time before the acts become effective. Here at EACC, we believe it's important to create a forum for education and conversation about issues and developments that have an impact on transatlantic business. Let's begin today's discussion by turning to Peter Fattelnig and asking him to give us a little history about how these acts developed and what they aim to accomplish. Peter?
Thank you very much. Greatly appreciate, Alan, that you call those two acts as not too difficult to understand. I would love to share that view, but I think both of them are actually quite massive framework regulations. And with framework, what I mean is that they are really putting in place a long-lasting way of how we think in Europe on the European single market, those services should be provided. But let's back up. So both Digital Markets Act and Digital Services Act are single market regulations. So they clarify the rules applicable to all actors on the European single market. Now it creates a level playing field, but it also has that element of extraterritoriality as there are many firms from around the world active on the European single market. So this is where and why they are concerned. You referred to some of the context already. You mentioned concentration. I would love to add to this list of grievances as well a little bit. There's a lack of innovation. I think we have not seen much innovation coming over the last few years. Perhaps some application innovation, but in technical term, not much is happening in the last few years. There's a lack of interoperability, which probably is one of the reasons why innovation is not coming as fast as we would like to see. There's a misuse of data. But at the same time, we actually observe a lack of use of data. A lot of data is collected and never used. There is a lack of good practices and sharing good practices across the industry, as this is very much a siloed industry, or the companies are not opening up to product conversations. So in short, we do see negative societal and negative economic consequences of misinformation, disinformation, and how this space is structured today. If I talk like this, this is a bit our analysis. We have done years and years of analysis to come to those quick conclusions, but also US Congress here has identified very much the same issues. If I just recall Cicilini's Big DAC report of September 2021, which in over 450 pages very carefully lists all the issues the US Congress in its many, many hearings has identified with the digital market here in the US. And it lists dozens of recommendations for policy actions, and probably most of them are actually taken up in the Digital Markets Act and the Digital Services Act. Also here in the US in Congress, you have a lot of conversation about what bills to put forward, where to start to correcting this market situation. But there are a number of them being discussed, some a bit further ahead. We will have to see how many of them are making it at the end, but that's maybe for another conversation. I also want to mention that states have stepped in regulating the digital services market. There is a law in California which just went into effect. There are regulations in Texas and also in Florida. They may be smaller bits and pieces, but they already indicate there is a desire to act. The Digital Markets Act and Digital Services Act are often presented together, though I would somehow often prefer they were not presented together because they are very different frameworks, regulatory frameworks. They're not necessarily brothers and sisters. They deal with different things in a different way, and their applicability is actually, at the end of the day, very different. The Digital Markets Act is a very narrow applied competition policy instrument only addressed to markets which already have tipped. So it's an ex-post competition instrument. Ideally, this instrument is rarely used, or perhaps in the longer run, never used again, as it is trying to avoid that markets or concentration in certain markets and markets being tipped. So it ensures, as a Digital Markets Act, it ensures to restore this contestability of digital markets by addressing some of the unfair business practices we have been observing in how gatekeepers are acting and protecting their market. So the regulation will kick off a process of designating certain firms or parts of a firm as gatekeepers. And if that designation takes place or goes through, a certain number of obligations will apply to that very small set of firms. I think my commissioners have been talking about how many firms could be within the scope of the Digital Markets Act. Having not done the designation, that's a difficult figure to give, and I also want to be careful in mentioning it, but I have seen our political leaders talk about figures of 10 to 15. So there will be, but there will be firms from other geographies, including Europe, being captured as well. Perhaps we could show this slide. Thank you. I spoke about what obligations will apply once you are designated as a gatekeeper. And there is quite a wide-ranging set of them. They are grouped here in chapters. I will not be able to go through them all, but this just gives you a visual impression where this is heading, what are those rules are. And I make just one example. For instance, on the left upper box, self-preferencing is quite an obvious one. So this means that if you treat services or products offered by the gatekeeper itself more favorably in ranking than similar service or products offered by third parties or others, that is self-preferencing, and that will not be allowed. Or preventing interoperability and portability. So gatekeepers usually have been very good in kind of closing up the space step by step around the customers they're working with. This is something we appreciate or we think should not be the case. So users must be allowed to switch services and have access to the data they actually generated themselves on those platforms. So there's a wide range of other ones. Most of them are quite common sense. There are a couple of ones which need more explanation or more thinking, perhaps. Maybe we don't have the time. Maybe there will be a question. Let's then go there. Where we are in the implementation of the Digital Markets Act, the final text is becoming available these days. The European Commission has started already preliminary work on the designation of gatekeepers. So I think a good point in time would be at the end of the year, or perhaps January, February, to see have these designations taken place, and then those obligations will start applying to the companies. So I think it would be a very good time next Easter time would be a very good time to see where we are again on the implementation of those obligations. The Digital Services Act is a very different animal. As the DMA applies perhaps only to 10 to 15 companies, this one will apply to all companies within the scope of this regulation, no matter what size. And actually, you see here a little bit all the different kind of business models or industry this is covering. So in our impact assessment, we estimate that about 10,000 companies will be falling under the Digital Services Act. Overwhelming majority, of course, of the European headquartered companies, but also many from other geographies around the world. And what it does, it sets us a single set of horizontal rules on content moderation practices for online platforms. And in particular, what are the rules around removing of illegal content, the interaction with the freedom of speech, and creating a healthy, well-informed public debate. So how do we do that? We do that in a risk-based approach. And depending on the platform, what the actual business model is, and the size of the platform, up to 16 specific obligations may need to be considered by the operators. The 16 you see here on the right side, there's probably you can't even read it, a list of 16 bullets with different obligations being spelled out. We have been working on the Digital Services Act actually since 2016. So this is grounded in a lot of preparation, but this is also grounded in a lot of trial work we have been doing with the platform companies. The code of practice on disinformation went into force in 2018, the first version. And we have been working with dozens of companies on what the issues are, how they can handle it. They have made commitment, so we learned from that. And I think what we do here is we are rolling that out to the entire industry now. Just giving you a bit of a snapshot or a taste of what is in there in these 16 different obligations. There are very obvious ones like having clear terms and conditions, where most people would say, well, that's quite obvious. Don't platforms have that? Well, not every platform has that today. So that's very important. There are conversations since years about transparency reporting. The OECD has been doing really, really good work the last couple of years, and there have been some reporting formats coming out of that process. So we think transparency reporting needs to be part of that as well. There are other elements like on platforms which bring buyers and sellers together. Know your business customer concept. This is also something we would like to apply in the online world and to those marketplaces. So the Digital Services Act is, in fact, as it stands right now, is a framework regulation. And what it will require is a quite large body of secondary legislative action and also guidance and best practices developed together with industry. So for each of those 16 obligations, you can rightly ask the question, how do I do that? For some of it, the regulation already has elements. For some of it, there is work outside ongoing, I mean, like the OECD work I referred to. But for some of it, we will have sort of to go to the drawing board and see how is that being best implemented. So in terms of time, when this will become effective and when you will see change on those platforms, that is a little bit difficult to estimate at this stage, because we are developing that secondary legislation as we speak right now. I think, again, spring will be a good point in time to see how much of that secondary legislation is there. That goes in a much quicker way because it's only the Commission deciding. So there is no political conversation or debate anymore. It's an administrative process. So the Commission is deciding on those rules. And only then we will see slowly the effects coming into place. Just the last word. while I now give the impression this will take years to implement, and that's maybe true. We also have seen with other legislation, it takes a while until all of that is taken up throughout the marketplace. However, with the work we have done on the code of practice, and there's actually a new version since July in place, we are working already with more than 30 companies, the biggest ones in the industry, to implement those rules. So you can, on a voluntary level, see they are already way ahead in implementing this, and most of them are actually already in place for the big platforms operating on the European market. I would like to leave it there and then open it up to conversations and questions. So thank you very much for having me here.
Peter, maybe you could, you've mentioned the discussions ongoing with in the US on these issues, but we've had experiences in the internet in the past where regions or countries develop their own kind of equivalent statutes that are different. Maybe you could comment on what you would expect would happen here, and do you see in this particular effort perhaps a more coordinated effect to address issues so that we don't end up with sort of widely different digital services in different parts of the world?
I think this is sort of a twofold question. On the one hand, it's important for Europe to move ahead. So I don't think a strategy which would delay action in Europe is going to work. So this is going to move forward in whatever any case. So that's quite clear. At the same time, we have a strong interest in the implementation of many of these obligations to use existing standards, to use existing practices, existing methods developed by industry. I mean, again, I'm referring to transparency reporting. A lot of work has gone into that by the companies. Actually, all the big platforms do transparency reporting. It's just not standardized. So we are interested, and actually this is what we are doing as part of the Trade and Technology Council as well, to bring to the table, say, can we agree on a standard on that one? I mean, a standard in terms of template is not rocket science. It's kind of, what are the things to report? What are the data formats? How can we aggregate this information? So it's this sort of conversations. So we are doing that, but it has to be done one by one. There are the 16 obligations. Some of them are easy. Some of them are very complex in itself. So that is ongoing. Certainly, I think none of these actions is I mean, except let's say the DMA. So I'm thinking about the Digital Services Act. None of these actions is aimed at reducing the market share of companies. It is aimed to create a better online world, because online content moderation is an issue. I mean, particularly with the war in Europe right now, we see that action is really urgently needed to have better companies acting better on the content they have on their platforms and help them to do so.
Thank you, Peter. Malcolm, maybe you can speak to us a little bit about these two acts and how they will overlap with some of the other things that companies are already dealing with, say GDPR or some of the other entities, and how some of the users of these platforms may be impacted. We've talked a lot about what the obligations are on the platforms. It'd be interesting to hear a little bit about how the users might be impacted.
Thank you. Well, I think firstly, in terms of the overlap question, it's really important to recognize that the Digital Markets Act, the Digital Services Act, essentially sit alongside, they complement or they supplement other regimes, including, crucially, GDPR, the General Data Protection Regulation. And one of the features that Peter called out is the extraterritorial effect of those various laws. If the relevant criteria are met, then organizations, businesses in the US are directly subject to elements of those laws, have to build compliance mechanisms and procedures to essentially accommodate those European laws, as well as the increasing patchwork of US state privacy and consumer protection laws geared to online activity. So it can look very much like a thicket of overlapping and somewhat sort of confusingly similar bits of law. So I think it's really important always to step back and to look at the precise focus, the policy targets of the respective legal instruments. And hopefully not oversimplifying, but the Digital Markets Act is essentially concerned with ensuring that there is a competitive market, there is contestability in the provision of online services, that the large platforms, the gatekeepers, don't act as inhibitors when it comes to innovation and the scaling up of small and medium-sized enterprises. They don't stifle startups. The Digital Services Act is differently concerned. It's focused on implementing measures to address illegal and harmful online content. And because they have different policy objectives, you can get from that to the explanation of how these laws are targeted. Peter mentioned that the DMA will affect a small number of large organizations, very large gatekeepers. It will, of course, have knock-on effects. So it will affect the relationships between those large gatekeepers, and in particular the business users of the platforms that they operate and provide. So when we're thinking about the building of compliance procedures, when we're thinking about that overlap, we do need to consider the distinct policy objectives of each separate part of the legislative suite. GDPR gives us a good starting point because it is concerned with the protection of personal data. And that personal data is really just a component of the overall universe of data that is being created, processed, commercialized on these platforms. So we need to think in terms of overlap about how, for example, some of the obligations under the Digital Markets Act on gatekeepers interact with GDPR when personal data is involved. So one of the obligations on gatekeepers is to make available to the business users of those platforms data that is generated by the end user. The platforms, the metas, the big players in this space have essentially had visibility of the pattern of data that is generated. Individual business users have not had that degree of visibility, have not had the tools necessarily to analyze how the platforms are being used, to analyze how businesses can make better use of data, can improve their services, innovate and scale up. So gatekeepers are being required under DMA to make that data available. Now that could be in aggregated or non-aggregated form. I'll come on to that in a moment. And it can include personal data. So when we're looking at the relationship between the gatekeeper and their business users, we need to be clear about precisely where GDPR fits in. And if there is a sharing of personal data and making available of personal data by the gatekeeper to business users, well, we need to work out what, for GDPR purposes, for example, is the lawful basis for that sharing. For the gatekeeper, it might be possibly compliance with a legal obligation. For the recipient, it might very well be legitimate interests. So we need to analyze that relationship and that data flow and make sure that following the requirements of DMA don't lead organizations into inadvertent non-compliance or incomplete compliance with GDPR obligations where they're triggered. We're looking at how they fit together. Then similarly, just to pick an example, a couple of examples from the digital services side of this equation, we're looking at elements of DSA that regulate things like targeted advertising. And one aspect of that is regulation of advertising that is targeted based on profiling of minors. Another is targeting of adverts regulated by, driven by profiling based on what's referred to as special category data, so sexual orientation, religious beliefs, and so on. That is absolutely an area of crossover, of interaction between DSA and GDPR. So in order to operate, in order to understand how DSA is applying, we need to be very clear about when special category data is involved. And DSA also goes to other aspects of that sort of advertising related and consent related interaction between users, businesses, and platforms. And that's when we get into some of the byways of issues like dark patterns. So while, for example, GDPR is focused on the actual protection of personal data, the relevant parts of the DSA suite look at things like the design of interfaces, look at how the design, the layout, the choice of words, the choice of tick boxes, radio buttons, prominence of particular statements might influence or manipulate behaviors. So it's interaction and remembering at each point that these are complementary and not duplicative pieces of legislation. Now, if we look across the range of obligations, my strong suspicion is that the larger operators are going to, as far as they possibly can, look to pass off, look to impose upon business users of platforms contractual obligations that include warranties, obligations, indemnities in relation to compliance with the overall objectives of this legislation, where there are obligations to monitor harmful content. The organizations that are directly in scope may well be seeking to impose contractual obligations on their constituency of users to pick up some of the strain of that activity and to seek recovery in the event that there are breaches of contractual obligations on the part of those smaller players. Those, I think, will come under scrutiny from a range of regulators. My final point really is that in order for this full suite of law to operate, it is going to require, in my view, a lot of cross-regulator, inter-regulator discussions. And I think greater clarity in terms of the handover points of responsibility for enforcement, monitoring, and checking. So it is a jigsaw, but it is a jigsaw of separate pieces, not duplicative pieces.
For those who are not, a number of our participants today are in the U.S. or other places. Maybe you could give just a very quick, high-level explanation of how that would be implemented. Is it through rules, through regulations? What can the nations do at an individual level? How will that all get sort of worked out as these come?
Peter, would you like to take that from a legislative perspective?
Well, go ahead first. You have such a good role, and let me come in then.
Okay. So, I mean, first of all, when we're looking at the relationship between parties, between commercial parties. One of the key things that we have to do already is to analyze data flows. And that data mapping exercise is the absolute foundation of working out on what are we advising. So are we looking at an interaction between businesses that is driven by personal data, as is the case, for example, with direct customer facing services? Or are we looking at something that extends beyond personal data and into things like usage data when it comes to numbers of visits, for example, to commercial sites? So understanding what data we're talking about is critical. If we look forward to the Data Act, then we have other sort of points of origin for data that of which sharing will be encouraged, and that's Internet of Things derived data. So understanding what data is involved is our point of entry for determining which laws apply and therefore which regulators would be relevant, which supervisory authorities would be relevant. And if we have points of handover between platform operators, businesses, and end users, that data mapping also really helps us to design the contractual links, the warranties, the indemnities, the normal contractual mechanisms for liability that avoid liability falling in the wrong place.
Yeah. I think that's a very, very good question. And in fact, from the GDPR, we have learned that the coordination of enforcement is key in building out a regulation which actually works. And I think that experience as well was used here by designating the European Commission as the sole enforcer for the very large online platforms. So, I mean, not that this guarantees perfection, but at least there's one place to go to. There's one place where things are happening. So it reduces a little bit the complexity of coordination and will certainly serve as examples then trickling down to other obligations or to the smaller platform obligations, which are then enforced by member states in the European Union. So I think, yeah, you have a good point. On GDPR, in the conversations here in the US, in Washington, what I often say, and then what people bring to me is that, you cannot have a Digital Services Act if you do not have basic other legislations in place. This is building a house with kind of Lego bricks. And if you want to put something on top, you've got to have the foundation for it. And in the data privacy regulation is a foundation for the DMA or DSA. Otherwise, you will not be able to make these sort of things work. You have been talking extensively about the data flows and how this has to be reconstructed. And you need a basic legal framework underpinning that. So I come back to the Lego bricks, and I think this is what you see in the European Union a little bit. A couple of bricks are in place already, the foundational elements. Now a few more bricks come on top of that, and that's the way this will go. Just the last comment, you spoke a lot about sort of data flows, and maybe we talk about online content, but this also concerns physical products being sold on online markets. And what we find unacceptable, for instance, that a bicycle shop were to sell bicycles which do not conform to standards applicable in the European Union. I mean, no bicycle shop would do that or survive that for longer than a week. Online places can do that so far. I mean, there is no liability in all of this built in. So you can buy bicycles which do not conform to European safety standards or American safety standards. And these are dangerous goods. We don't want that on our marketplaces. So there is also sort of bringing the online world to the level of quality of the offline world we already enjoy. And this is another product safety element of the Digital Services Act.
Yeah, I'd like in a moment to turn to Lucinda and talk a little bit about how this may impact some users. But before we do that, Malcolm, maybe you could give us just a quick overview about how the UK is dealing with this after, now that it's sort of a separate but related entity.
Well, Alan, that would be a $64,000 question, which, as you know, today is a £64,000 question. The UK is potentially, in some regards, going its own way. We have the Online Harms Bill that is looking to address many of the same questions in terms of harmful online content as the DSA. I've got to say, at the moment, it is not clear whether and how far or how fast that legislation is going to proceed. It went into committee in June. In July, its progress was paused pending the appointment by some tiny percentage of the UK population of a new Prime Minister. And it hasn't yet had any dates allocated to it for its third reading stage or going through the House of Lords. So the UK may or may not implement something that covers much of the ground of the Digital Services Act. We also have the potential for the UK, to an extent, going in a divergent direction in terms of personal data protection. But again, the Data Protection and Digital Information Bill, which was supposed to have its second reading on the 5th of September, hasn't. And it is not yet clear how far the new administration is committed to driving that legislation through Parliament. I really can only note that the UK appears to be having a bit of an episode at the moment.
So I guess I would summarize that as we will wait and see how things develop here. Before I turn to Lucinda, I just want to say to our attendees, if you have questions for any of our participants, you can put them in the Q&A. You can use the Q&A function on this webinar, and we'll try to make sure that those questions get answered. Lucinda, I think that it would be very helpful if we could hear your perspective on all of this, and in particular, what types of digital services it'll apply to, how particularly U.S. companies, given the number of U.S. attendees we have, might be impacted. And so let me turn the floor over to you for the moment.
Thank you so much, Alan, and it's great to join the webinar, and I've really enjoyed listening to Malcolm and Peter too. So I don't want to sort of duplicate what's already been said. I would very strongly support the kind of idea that this is, it's part of a wider tapestry, if you like, of regulation of the digital world generally. And if you take the Digital Services Act, it doesn't come out of nowhere. It builds on the e-commerce directive, which goes back to 2000. And we also have, I think, really importantly, a new cybersecurity proposal, which actually has only sort of been published in recent weeks, and that too feeds into this, of course, because there is a greater onus on platforms and anybody really operating online to ensure that they're going to be compliant with that too. So it really is a melange, if you like, of regulation, which it can seem a bit daunting to companies, especially, well, to all companies actually, the large, the small, and those in between, because of the cost of compliance and the fear of the unknown. But I suppose you can flip it from the other point of view and say, well, actually, this increasingly provides greater certainty, or at least that's the objective. And the more certainty we have, the more companies know what they're dealing with. So, it potentially reduces the risk for huge multi-billion euro fines, which to date are primarily not by design, but by dint of their sheer size. They are primarily targeted at huge US tech companies. So if you take even in just in recent times, the massive 2.42 billion fine for breaches of competition law imposed on Google, or if you take, all of the other platforms at different stages in the past decade or so, they've all in different ways been hit by fines arising from what's considered to be anti-competitive behavior. And I certainly hope that the DMA, for example, will actually provide much greater clarity and much greater data and information exchange between regulators at EU level, and indeed as this progresses in other jurisdictions across the globe, and those platforms. And the practices that have led to these types of fines actually may become far less prolific, and that may benefit everybody, from the companies themselves to the regulators to smaller platforms and companies that are interfacing with those large tech companies and platforms, and also ultimately consumers. So that's a glass half full perspective, perhaps, but one that I think is important, that we focus on too, because I think often, this is seen as the European Commission being, sort of, people, I suppose, have their own opinions, but actually, I think the motivation is largely good, and I think. As I think Vice President Vestager said in the context of the DSA, this is, and Peter has alluded to this too, it really, the intention is to make illegal online what is already illegal offline. And that's a really core sort of principle here, and one that I think we can probably all agree with. It's just a question of how we get to that point. So there are, a lot of unknowns in terms of how this will actually be implemented, and I think it will take a lot of time. I think what's interesting, and we can, delve into this in a bit more detail as we go on into the Q&A, but I think what's really interesting is that there is a really large degree of self-regulation involved in this, and there's also a really large degree of sort of collaboration between the regulator and companies that will be impacted. My experience of the European Commission in particular is that it proactively engages in public consultation and industry consultation on a kind of constant ongoing basis, and this is actually effectively going to be enshrined in this legislation, which I think is really interesting and really presents an opportunity for the large platforms, but also for the smaller platforms who interface with them. I think if you look at the regulation, that becomes quite clear. So the legislation, for example, gives the European Commission the power to invite any online platform or search engine to participate in the application of complementary codes of conduct. It also specifically refers to existing regulatory codes, which all of the large tech platforms are already participants in anyway, like product safety pledge, or there's a memorandum around counterfeit goods. So, that's existing sort of self-regulatory codes that are already in place, but there's I think huge potential for more of these. Codes around other types of illegal content, online advertising, the protection of minors, which Malcolm already alluded to, accessibility to services or goods for people with disabilities. And so, there's a real opportunity, notwithstanding the fact that this is legislation that has been negotiated and agreed by the co-legislators at European level. There's a huge amount of opportunity still to influence and actually input into that process, which I think is kind of unique and is quite interesting. I certainly think presents an opportunity for companies of all sizes who will be impacted by this legislation. Just you asked about the sort of the type of content that will be impacted. So hate speech, I mentioned. Hate speech is always a little bit unclear. It's a bit subjective. So I think this is going to require quite a bit of work. We already have existing legislation in EU member states. For example, there's a law in Germany called the NetzDG law, and I think that presents at least a track record in terms of how it has worked. And we have seen from Germany some of the things that have been good, some of the things that have been bad. And I think that provides at least some kind of track record and experience for the European Commission to look at. Things like content involving child exploitation, the sharing of private images without consent, terrorist content, of course, sale of counterfeit goods, unsafe products, which Peter has mentioned. All of this will be covered by the legislation. Copyright infringement, of course, which has been under scrutiny in Brussels for quite some time, and I think that all of that is quite clear and relatively straightforward in terms of the focus of the European regulators in trying to address it. Which type of digital services? For the DSA, you're talking about marketplaces, app stores, collaborative economy networks, social media, of course, content sharing platforms. So it's quite a wide scope, and companies with a substantial connection to the EU, that's fairly self-evident. I suppose the DSA is interesting because it does treat differently, as Peter outlined, smaller entities, smaller platforms, or marketplaces, as compared to what are called VLOPs, very large online platforms, and they are going to be subjected to stricter and more far-reaching requirements in terms of what they are expected to do to mitigate systemic risk. And so, they have broader responsibilities and requirements than smaller companies. So I can get into some of the detail on that in a moment. I think one of the key things that I would highlight are the transparency requirements, what they look like. So the transparency requirements generally for commercial and political advertising. There will be a requirement for labeling, identification of sponsors, the amount of money spent, targeting criteria, the creation of publicly accessible repositories. So that's all new. It's, I think, fairly self-evident, but it will now be a legal requirement, and companies will have to comply. And I think that will be a significant transparency requirement for all companies that are impacted. For the larger companies, the VLOPs, then you were talking about a specific focus on algorithms, and there will be requirement on the larger companies to re-engineer their systems, providing options for users so that they can opt out of profiling, which is new, and they will require significant changes to how platforms interface with users. So a significant amount of preparation, I think, will be required. At the latest, this will be mandatory by the 1st of January 2024 in the case of the DSA. So that's it's a reasonable lead in time, but will require fairly significant changes in that period of time. And likewise with due diligence obligations, companies will be required to provide regular transparency reporting in cooperation with the national authorities where they're operating, and that will for sure involve an administrative burden that doesn't currently exist. But again, it will be a greater requirement for the larger companies who will have to create new compliance functions within their company, and they will have to have they'll have to be at a certain level in terms of C-suite and have direct access to top management within the company. So that's a new requirement and I suppose an additional compliance burden, which is greater for the larger companies than for the smaller. So there's some examples, but there's obviously a lot more to it, and I'm happy to talk through some of them as we go.
Well, I think we're down really to our last few minutes of our time today. One of the things I'd like to ask each of our panelists to do, because as I've said, the audience for this webinar will not largely be the very large platforms. They're businesses of all different types, but many of them offering online services or utilizing online services or dependent on online services. And I'd like you to share a few thoughts directed at those companies as this process continues and as these acts come into force. What should they be thinking about now that they may have to prepare for into changes for their business? Just in a short brief, we have only about 3 minutes total left. So maybe Lucinda, if you have any thoughts, we'll start with you.
Yeah, I mean, I think it's really perhaps for some companies changing the mindset so that they become systematic in how they meet transparency requirements. So, putting in place a structure for regular reporting to demonstrate compliance with transparency requirements under the DSA in particular. I mean, the DMA will be have less of an impact, frankly, on those smaller companies. So I think preparing, and actually one of the things in the DSA is that the large tech companies may be actually obliged to provide templates and to share information with smaller companies to make it easier for them to comply. So I think let's watch that space. I think that's a really interesting concept, and it's one that makes sense. Because it will enable their partners and customers in many instances to comply without a huge financial burden. But certainly, I think all companies should be just looking at ensuring that they have regular processes in place to ensure that they comply with the sort of transparency requirements that are contained in the DSA. And I think preparation will be key, and getting started on that at an early stage will ensure that they're ready for when it becomes law ultimately in just over a year's time.
I think that's helpful. Malcolm, let's go to you next. Any last minute sort of practical thoughts?
Yeah, so 2 points really. The first is when you're looking at which laws apply, I think it's essential for US-based organizations to recognize when EU laws apply them, either because they have a presence in the EU or because they're directing online activities towards the EU, UK. And one of the reasons for having clarity on that is that if you're looking at putting together a compliance procedure or working out what is possible, you need to be alert to some subtle changes of subtle changes of possibility. For example, the way in which US privacy practitioners tend to talk about anonymization of data or aggregation of data differs quite markedly from the EU concept of anonymization, and working out where that sits is difficult. Second point, in terms of who is the responsible person at C-suite level, one thing we've learned from GDPR is that you need to make sure that there is a good degree of independence on that person's part, so that you're essentially advising critically rather than underwriting decisions that are being made, and certainly that you're not marking your own homework. So I think those 2 key points.
Very good. And Peter, as we run out of the end of our time here, any final?
Adding to it, I think companies could consider whether they will be a beneficiary of the Digital Markets Act. It's maybe you are working with a company which will be designated as a gatekeeper, so obligations will apply to them. What does it mean for you? Will you have access to data? Does that change your business case? Does that help you sort of building out whatever you have in terms of products or services pipeline? So I think there are beneficiaries of the DMA, and you could be one of them. Thank you.
Very good. Thank you. And on behalf of EACC, let me thank each of our great speakers today for their contributions. I found it a really interesting discussion. I'm sure our attendees did as well. Thank you again for your participation. Thank you for attending. And we'll sign off for now. Bye, everybody.
So this concludes today's webinar. And as Alan said, this was a great discussion. And I hope it answered some questions. I'm sure it triggered others, which you can send to us and have them answered by our panelists. So many thanks to Lucinda Creighton, Malcolm Dowden, Peter Fatelnik, Alan Sutton for sharing your invaluable expertise, insights on how US-based companies should anticipate on those EU tech rules. And thank you also to Edwina Lau and her team from Greenberg Traurig, who worked behind the scenes to ensure that this webinar was technically flawless. Many thanks and goodbye.